My name is Lieutenant Colonel Lee Roger Wolfgram, and I am a storyteller.
Hey everyone, welcome back to the Colonel channel. I am your self-proclaimed commander, Lieutenant Colonel Lee Roger Wolfgram, and today we're going to talk about a Brady violation, and we're going to use the Alec Baldwin case to illustrate how a Brady violation works. And in this case, it actually ended up in a dismissal because the state concealed or failed to disclose evidence that would be relevant and material to the defense. So with that said, the judge at the end will go through exactly what the Brady violation was, but I think this is interesting to illustrate what happens when the prosecutor does not turn over all of the evidence to the defense. And we're going to start off with their state's lead investigator on this case, and this is really where it starts to really unravel for the prosecution. And then the prosecutor takes the stand and didn't need to take the stand, and I just think it killed her. With that said, let's jump in and watch the video.
Look, you just testified. Let me just ask this. None of these look similar to the set on rust.
To the live ammunition.
To the live ammunition on
Yes,
rust.
ma'am. Yes, Your Honor.
But it still looks similar to what was on rust.
Yes, yes.
It looks similar to these on rust.
For the dummies, yes.
Yes, it looks similar to dummies on rust.
Dummies, but not live.
Okay, I understand your distinction on
Okay.
live. But they still look similar. That one, the third one from the left, still looks similar to dummies on rust.
Yes.
All right, thank you. That looks similar to the dummies on rust.
Yes.
You didn't differentiate, and that some of the dummies on rust were sent to the FBI.
Yes.
Okay, thank you.
You were here for investigator, I'm going to do this again, CST Popple's testimony yesterday, weren't you?
Yes.
And you've had an opportunity to view the 45 Starline brass that came out of this package today.
CST is a crime
No.
scene
You haven't looked at
technician.
it yet?
No.
Okay.
She was excluded as a witness, I think.
Are you aware, as you sit here, that there was 45 long cold Starline brass nickel in the courtroom today from CST Popple?
I just found that out today.
Okay. So, you were here for this testimony in this courtroom. And let me ask you, Ms. Popple, the ammunition that the Good Samaritan, Mr. Teskey, the close friend of Hannah Gutierrez's dad, when that ammunition that he brought into you after the conviction, you still have it? Answer, yes. Question, you can bring it in here and you can show it to the jury, right? Answer, yes. And they can see for themselves that it does not match the live ammunition from the set of rust, correct? Yes. And that it is obvious. Just when you look at it, it is not. Yes. Do you remember that testimony that you were sitting here for?
Yes, I do.
And that turns out to be completely false, doesn't it?
You're correct.
Mr. Teskey showed up here, according to you, at the Hannah Gutierrez retrial, correct?
Yes.
And Mr. Teskey then walked into the police precinct with ammunition that he claims and says is matching to the ammunition that struck Ms. Hutchins, right?
I don't think he ever made the statement it was matching.
Well, that's really for law enforcement and the FBI to decide, isn't it?
Which would have been investigated if he would have answered a phone call or returned a phone call.
Okay, and I know we're going to get to that, don't worry, but wasn't the first excuse you gave, Corporal. The first thing you said when this came up on direct examination was that you didn't know it was related to this case. Do you remember testifying to that on direct?
How would I have known if I wasn't given an opportunity to talk to him myself?
You would have no way of knowing that the man who was on speakerphone with you talking to Seth Kennedy, the man whose screenshots you received, the man who showed up at the Hannah Gutierrez retrial, the man who walked into your precinct talking about the Rust movie, you would have no way of knowing that it was related to Rust?
I would have need to come to the conclusion myself that it could have been tied back to Rust. There's been many people throughout this investigation that state that they have evidence or testimony to give that wasn't in relation to what I was doing.
Uh-huh. So is there other evidence in this case that has this quantum of proof that you have hidden from the defense?
I don't think I've hidden anything.
Is there any other evidence in this case that you think this court should be aware of, that you're aware of, Corporal Hancock?
No.
And when Mr. Teskey came in, he stated that he believed it was from the same batch of ammunition that was located at Seth Kenny's warehouse in Albuquerque, correct?
When he came in?
To the precinct.
So sorry, I just want to understand this.
Mm-hmm.
You're saying that Troy Teskey made the statement to law enforcement that the ammunition matched rust.
Correct.
Where is that statement coming from?
In your own police report.
Okay.
I'm reading it.
Okay, so that's not my police report.
I didn't say it was your police report.
You
Corporal.
just said it was.
No, I said in the police report.
Just as a point of clarification, can we?
Is this an objection or is she just talking?
Yeah, you gotta have an objection, okay? I said that, no running things.
My
Speak.
request is that we correct the record with regard to Mr. Spira's.
That is
statement.
not an objection.
Okay.
What is your objection?
I want to correct the record that you
One
actually did
word.
say I'm showing you your police report.
He's corrected himself, a police report. Some follow-up questions. So, on testimony, I don't know which one, who asked it, but anyway, you understood that Troy Teskey came over to the court and the deputies told him to wait for you, and that when you came down, he was gone, correct?
Yes.
Okay.
I don't know if exactly when I came down, but when I was looking for him, I was told he had
Okay,
left.
all right, and at that point, you were aware it was Troy
Yes.
Teskey?
Yes.
Okay, so then you find out that because he couldn't, well, assuming he couldn't reach you here, he went over to the sheriff's office, right?
Yes, ma'am.
And when you say today that he did not, he said these weren't from rust, that's from you reviewing the lapel camera, correct?
That they were not from the set.
The set, and that's from reviewing the lapel camera, correct?
Yes, ma'am.
Okay, and you just reviewed that today, you didn't review it before?
That's correct.
All right, so when you find out, I assume from Popple, that he was over there and he dropped off the ammo, right?
Yeah, but I'm not exactly sure who told me, but
Okay. You can't confirm or deny that, well, you didn't know that he said it wasn't from the rust set. In fact, the report says that he says it was from the rust set, correct?
right, which I had just reviewed today as well.
Right.
Yes.
But when Popple when you were advised that Troy was there or was there, your understanding was that he was claiming it was from the rust set.
I wouldn't say it was from the set, but it could be in relation to rust.
Okay, so he told Popple it was related to rust.
Yes.
Okay, and you didn't go over to the sheriff's office and look at the ammo.
No, I was here.
Well, I understand you were here, but you didn't, you said, well, Hannah Gutierrez's trial was over, which I took to mean that it wasn't pressing, but this case was ongoing at that time.
Yes.
So, did you and Popple have a conversation about what to do with this ammo?
To my understanding, it was going to be put in evidence
Which evidence?
at the sheriff's office.
The rust evidence?
No.
Why
Just-
not?
Just as far in our evidence section in the sheriff's office.
And why was that determination made?
As to why
Who
it
made
was.
it? Let me ask you, who made it?
These were discussions that were had with myself, with The supervisors at that time, and then with the prosecutors.
Were you the lead investigator?
Yes,
Okay. And you said, and with the prosecutors?
yes, ma'am.
Okay, so you all had discussions about what to do with what he dropped off?
Yes.
This is a really important part because the prosecutor is involved here in deciding that these rounds are not relevant and should not be disclosed to the defense.
I can't provide the video until she logs into this system. Mr. Spires
You know, I
has-
don't even think the video's relevant. She did not view it until today, so you can look at it, but do you have any cross-exam for her?
Just need to develop my records, so I need to get the video in. I need to get the video.
You can get the video in, okay? Are you gonna get it in through her? Because I said it should come in from the person that wore the body
I
camera.
agree with you, he's here.
Okay, well, fine. So, do you have any cross-examination for her? When you say that there were discussions and the decision was made by all of you to put that ammo in a separate file, right? Is that correct? You said that?
Yes, ma'am.
Was Ms. Morrissey part of that discussion?
Yes.
Thank you.
Hey, good. I'm Lieutenant Rowe. Lieutenant, so nice to meet you. I've got some evidence. You need to do this out here? Because I should probably write out something to go with this.
Like a chain of custody.
Statement,
Well,
yeah.
we would have a chain of custody there. So, yeah, come with me and we'll go.
What I was, when I'm a witness, I'm called here as a witness to the Gus trial. Yeah, I don't care what you do, I just don't want to have it. And they're 45 cartridges, like,
That are from the set?
no.
Okay.
No. You want to know the details?
Could you hear what the gentleman said?
Yes,
Was he asked if they were from the set?
yes,
What was his response?
no.
Or do you want me to
Well,
write it down?
let me start with, what is your name, sir?
Troy, well, that's a great start.
Troy what?
Troy Teskey,
Can you spell that for me?
T-E-S-A-E. I've got all kinds of identification. You should see it on
And where are you getting called by?
a retired police officer.
By
and-
the defense. Defense, okay.
Yeah, but they didn't end up using it.
Okay.
Here's my police ID. And then I'm also a judge. You need to see that.
Sorry. Move down. Okay, so they were gonna have you bring 45 rounds?
Yeah, and at the last minute,
They talked to
The
her,
defense.
him on the phone. He was good, he said that they were gonna have somebody pick it up from Rosemont, which they never did. Okay, so he brought it out here just in case. And-
Becky, this is my story.
Okay, but get it out of there. Don't want it anymore. This is-
Sir, do you recall this conversation?
Yes, I do.
Do you know, when Mr. Teskey is talking about being called as a witness in the Gutierrez trial, do you recall which side he was being called by?
I only learned that when he identified that.
What
Speaking
side?
On the defense side.
And when he said that he brought ammunition, but they didn't want to use it, was he referring to the prosecution or the defense?
I,
Is there any basis to know that?
If he doesn't, I'm assuming he'll tell me.
Sorry, I want to go.
They told me to. The defense attorney said, hey, why don't you bring those rounds? And I thought, and two times, Hancock and then Morrissey. Hancock first said way back on November 5th, and November 5th of 2021, which was a week after the shooting. Seth Kinney called me, you know Seth? Everybody seems to know Seth here. But, Seth, he was a friend of mine. And Seth Kinney called me from Hancock's office. She was a detective at the time. And he said, "You're on the record. I want to know what's going on with, because I have these rounds from, it's the same batch. They came from Joe Swanson.
Okay.
Know him too?
Yeah, I know of everybody.
That's
I've
awesome.
dealt with this case a lot.
Okay, well, that's perfect. You're the perfect person to what's your first name?
Marissa.
Marissa? Oh.
Yeah, I apologize. I'm the crime scene technician.
All right, well, I better jot that down. But I have some good notes on it. So my big concern was having these, they said, oh, okay, I said, I have these rounds, I have a batch, a whole bunch of rounds.
Okay.
Or a bunch. And then, I said, well, you probably don't want me to send you the whole batch. You want me to just pull something out and send you a picture. So I took a picture with my phone, sent it to Seth, and he was in the office with Hancock. They looked at it, and Seth said, yep, this is evidence from the accidental shooting. The accident.
Now, when you
Yeah.
say they're from the same batch of
Yes.
live rounds?
Yes.
Okay.
It's, if you know the case, Bell Reed had a whole bunch of live rounds.
Yes.
And they, Seth and Fell went to Yellowstone 1884, 1883. And he was teaching people how to shoot with these rounds.
Right.
Then they left there and they went together from Arizona. And then they came back and went to another set, which was,
Sir, why did your video end there?
Because I walked out of the interview and was attempting to, or I did contact Detective Hancock to see who this individual was and why he was there turning in evidence like he called it.
Okay, did you know what it was evidence of?
He'd mentioned that it was tied to the Russ case.
Okay. And you called Corporal Hancock, right?
Correct.
And do you recall the conversation you had with her?
Yes, I asked her, an individual is here, gave her the name. I said, he claims that he has evidence. How do you want me to proceed turning it in and documenting it? Or if she was available to come over and interview him. And at that time, you guys were still involved in the Hannah Reed case, so she was unavailable. And she asked that it be documented, and she would have to do further investigation onto it and interviews.
Okay.
Good afternoon, sir.
Good afternoon.
The witness that was in the precinct told you he was a retired police officer, correct?
Yes.
He offered to make a statement multiple times, correct?
Yes,
Told you he was a witness multiple times, correct?
he did mention that.
Yeah. Told you he had evidence multiple times?
He did call it evidence, yes.
And when Ms. Popple comes into the room, or when your camera comes into the room, she says, I've dealt with this case a lot, right?
Yes,
And Teskey says, you're the perfect person, right?
yes,
And it was obvious from the conversation that Ms. Popple knew who Joe Swanson was, who Seth Kenny was, right?
yeah, she was familiar with them.
Yeah. And that interview of him continued, correct?
I believe he was speaking on his own accord. We weren't conducting an interview. He was just there to turn in the evidence that he claimed he had.
It should be noted that this is not actual evidence from the death investigation collected by SFSO detectives. That's what you wrote, right?
Correct, and it wasn't collected by our detectives for the investigation.
Detective Hancock, who was at the courthouse with Ms. Morrissey at the time, directed you to put it under a different identification number, correct?
Correct, pending further investigation.
Okay. You were involved, actually, you're copied on some emails with evidence viewing in this case.
I believe so, yes.
Right. You have no reason to believe that law enforcement ever showed this evidence to the defense, correct?
Correct.
I have nothing further for this witness.
Thank you. We're in recess.
Hey, can you just make sure that Ms. Morrissey is sequestered during the break?
I'm gonna stay right here.
We're back on the record.
The court indicated that you wanted me under oath, and I'm happy to do that. Where would you like me?
Well, okay, so just clear, you're a witness, okay? So you can say oath or whatever, but are you calling yourself as a witness? Or do you want Mr. Spiro to call you as a witness?
It doesn't matter to me. How do you want to do it?
I don't think it's necessary, frankly, for this evidentiary record for me to call Ms. Morrissey. I know what happened, and the court knows what happened. I don't think we need anything further.
Okay, do you want to call yourself as a
Sure.
witness? No, well, just a minute. So he's willing, as I understand it, to rest now, okay? Now, you don't have to say anything under oath if you don't want to.
No, I'm happy to.
Okay, so not only happy to, you know, I don't, it doesn't matter to me whether you call yourself as a witness. It doesn't matter to the defense whether you call yourself as a witness. So if you're calling yourself as a witness, there's no one here that's requiring you to be called as a witness.
The information, everything that happened in this regard, especially as it pertains to me, needs to come out in the public.
All right, so you're calling yourself as a witness.
And I am, and it was my understanding that the court indicated to me previously that you wanted me to testify. I understand you've now changed your mind. I think it's a good idea if I do it.
I do not think it's a good idea. The record's already been made. I don't see this helping the prosecution whatsoever, and her personally as an attorney. I believe this was a terrible decision, and you'll see why. This thing unravels, and she's a terrible witness for herself.
Would you like me? Okay. Do you want me here at the podium?
No, on the
Okay,
witness.
sure.
All right, Ms. Morrissey voluntarily calling herself as a witness without any requirement by the court to do so, or Mr. Spiro asking her to. Please raise your right hand. Do you swear affirm under penalty of law that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right.
This is all a result of misplaced arrogance that she believes that she's going to be able to clear this all up. And what you're going to find out is that she is completely unprepared and non-responsive to the questions.
And I decided not to take any steps to collect this ammunition. And that's all of the information that I can give the court, but I'm happy to answer any questions.
Can I ask a few questions, Your Honor? When you took over this case, the investigator handling the case, Mr. Schilling, left the case, correct?
At my request, yes.
The paralegal that was handling this case with you left the case, Mr. Tabb?
At my request, yes.
Well, the first prosecutor that was working with you on this case, you selected, correct?
I did.
And he resigned too?
I wouldn't say that he resigned, no.
Okay. He didn't stay on the case for the Alec Baldwin trial, correct?
No, and he indicated that that was because he represented a labor union that's a national labor union, and he was not expecting the trial to be set so quickly. He wasn't expecting it to be set in July. So when he realized that the trial was going to be set in July, he was going to be in collective bargaining agreements for his national labor union, and he wasn't going to be able to have enough time.
Linda Johnson, the next prosecutor selected, resigned from the case today,
She did.
based in part on the conduct we're here discussing, correct?
I believe that Ms. Johnson Ms. Johnson didn't want my understanding is that
So I just want to mention something here. So these answers are non-responsive. The defense counsel's letting her talk, but he really asked her a yes or no question. He's letting her continue because he's letting her dig a hole.
he didn't agree with the decision to have a public hearing.
On July 1st in this matter, you served a certificate of compliance with 5501, correct?
I did.
And you've never turned over the report or any of the evidence that we're talking about here at this hearing, correct?
Let's take it one at a time. I did not turn over the report. I didn't have a copy of the report. The rounds that were left at the Sheriff's Department by Troy Teskey, I have absolutely no reason to believe that they are relevant to the incident that took place on the set of Rust. These are rounds that were in the possession of Thel Reed and never left the state of Arizona.
You also did not allow the defense to view that evidence at any point during our request to review evidence in this case?
I had never seen it, and I didn't realize that it wasn't under the same case number because I'm not a law enforcement officer and I don't work at the Sheriff's Department.
But you are the prosecutor, and you say you never even looked at this evidence, and someone came in and said that this was evidence in the trial, 2 trials, that you are lead counsel for.
You are right.
And you concede that they are Starline brass, silver 45, right?
I can. And this is the best evidence against Hannah Gutierrez.
Yeah, you've said that a couple of times. Any favorable evidence you understand as a prosecutor has to be turned over to the defense, correct?
I do.
Any evidence that could be used as a defense to potentially be favorable has to be turned over to the defense.
Absolutely.
So the third Hague report that never got turned over to the defense, you understand that that's Brady evidence?
I did, yes.
Okay. And you also failed to turn that over in this case as well, correct?
And let me give you a full answer to your question. When the second Hague report came in, and I provided all of this to the defense, I sent it to the person who is managing the discovery server and asked them to upload it. It wasn't until I realized during pretrial interviews that it wasn't there that there was a problem with it. So I then attempted to figure out what the problem was, and it was indicated to me that it appeared that the former paralegal who was working for the special prosecutor had removed it. So we then immediately provided it. Then during the pretrial interview of Mr. Hague, it was brought to my attention that the defense did not have the August 31st report that indicated that the gun functioned fine, perfectly fine, and that was provided immediately. I went back, I checked my email, I could see that I received it from Mr. Hague and failed to forward it on to be uploaded, and I provided it as soon as I was aware that you did not have it.
A long answer to no.
The fact that nobody at the Hannah Gutierrez retrial cross-examined Mr. Hague about the report didn't clue you into the fact that nobody had the report?
Actually, it didn't, and I'd like to address that. The reason that it didn't clue me in is because Hannah Gutierrez's defense was that the gun worked perfectly. The defense in Hannah Gutierrez was never interested in any evidence that there was an issue with the gun, because if there was an issue with the gun, it damaged her case.
Who cares? This is the Alec Baldwin case.
So what you could see, if you watched the trial or saw any of the transcripts, the defense actually brought in their own expert to say that the gun worked perfectly. So they had no interest in that information.
And actually, you elicited testimony from Mr. Hague at that trial that was inconsistent, at least partially inconsistent, as the court's aware, with his third report, correct?
Tell me what you're referring to, and I'll answer your question.
Well, there was a whole hearing about this where you saw this, and you saw me go back and forth with Mr. Hague for 25 minutes, so I don't...
I agree, but I need to know what you're talking about for me to answer your question.
Okay, if you can't answer the question, you can't answer the question, I'll move on. As I asked you about Mr. Hague, yesterday when Ms. Popple testified, you would agree with me that her testimony under oath was false.
What part of her testimony was false, and I'll answer.
That she said that these rounds don't look anything like the rounds on the set when you elicited that testimony.
I agree with you, and I didn't realize that there were rounds that looked like that.
It's okay. In any event, when the court, and you never tested those rounds either, correct?
Any of the rounds that came from Mr. Teskey? No, because they came in just a few months ago.
And the court asked you actually one question that I want to address, which is, the court said to you, well, what's interesting to me, to be quite honest, is that yesterday you didn't even want to do a written reply. You wanted to just give an oral response. And what you said to the court was, I never saw these, I've never seen these, and I never saw the report. I have absolutely never seen these until this morning. Do you remember saying that to the court?
With regard to the 3 Starline brass, with regard to the 3 cartridges that appear to be similar to rust, yes.
Well,
I never saw them until today.
Well, but you said also, I never saw the report, right?
I never did.
Right, but don't you think, given your duty of candor to this court, that that's awfully misleading to not tell the court at that point that you knew about this when it occurred long ago?
That I knew about what?
You knew that Mr. Teskey had turned in this evidence, that you knew that the report would have existed because you just told this court that the doc report was okayed by you.
Sure.
Don't you think it was misleading to this court to not just say at that point, you know, just so you know, I know about this, I knew about this then, I was involved?
I did not intend to mislead the court.
The truth of this matter is, you don't like Mr. Baldwin very much, do you?
You know, that is absolutely untrue. I actually really appreciate Mr. Baldwin's movies. I really appreciated the acting that he did on Saturday Night Live, and I really appreciate his politics.
You told one of the witnesses who disagreed with you during an interview that you thought Mr. Baldwin was a cocksucker.
I do not recall saying that. I know that that was something that Mr. Baldwin would say on the set of Rust. I don't recall saying that.
Do you deny that under oath?
Without having more information, I can tell you that I do not recall ever saying that. And if I did say it, I invite you to point it out to me.
You called him an arrogant prick to another witness.
To who? To what witness?
I'm asking you, did you call him an arrogant prick during a witness interview?
I don't believe I did. I don't recall.
Do you deny that?
Without knowing what you're talking about, all I can tell you is that I can't respond if I don't know what you're talking about.
And you said also to witnesses that you would teach him a lesson.
I never said to witnesses that I would teach him a lesson. Absolutely not. In fact, Mr. Spiro, I want to give a full response to your question. I made every effort in this case to resolve this case with your client in a very favorable way for him.
All right, I'm going to move to strike this. It's not responsive.
It is responsive.
I don't want to talk about plea negotiations.
Yeah, and it's not responsive. So I have no further
Do
questions.
you have any follow-up testimony? All right.
I want to say I have no recollection of calling him any of those names. I have invited the defendant to tell me what he's talking about, and he has declined. I want the court to take notice of that.
See how smarmy she is and how smart she thinks she is? This does not play well with the judge at all. You're going to see. Watch.
Thank you. You may step down. So, dismissal with prejudice is a very extreme sanction.
And this is what the defense is asking for in their motion. They're asking to dismiss it because of a Brady violation, which I explained in the beginning. And now the judge will tell you exactly how she analyzed it.
And case law is very clear that because it's very extreme, I have to go through every single element, and I have to make a very good record as to why I'm seeing what I'm seeing. So, in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teskey gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense.
Impeachment evidence is evidence that you use to show that someone has lied under oath.
Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state. Quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions under Harper. Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated, State versus Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has power, inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted.
Okay, so the judge granted it, and I did predict in opening statements that this would be, the defense would prevail. I said acquittal, but at the end of the day, the state's case was always weak. The state's case was primarily based and initially prepared to hold liability for Alec Baldwin as a producer. And shortly before trial, the judge ruled that he did not have liability as a producer and had to solely focus their case on him as an actor. I predicted an acquittal. Instead, we got a dismissal. At the end of the day, Alec Baldwin is free. The state cannot do this. I'm very satisfied with this decision by the court. And this shows you how easy it is, if the defense is not on top of this stuff, for the state to get away with this. Until the next time, this is Lieutenant Colonel Lee Roger Wolfgram at the Wolfgram Worldwide Headquarters. Wolf 6, out here.